Just days ago, LIEnette and John CROOK were served. They now know we're suing them in federal court. Don't worry, we got receipts, we got proof, we got timelines, we got all the screenshots. Why federal court? Because this county court is a kangaroo court. Judge Craig DeThomas is out of control. This man doesn't belong on a bench being a judge at all. So we're going to the higher standard. We're going to the higher ups who will not tolerate individuals such as LIEnette continuing to interrupt. And frankly, if she does, she'll be held in contempt. She'll be in jail immediately. She will not be able to be a pro se litigant. She must have a lawyer representing her, or she just lets it all go. One or the other. It's either going to be a $30,000, $40,000, $50,000 retainer, or she doesn't show. What does that mean for Ohio, though? Well, we're still pursuing things in Ohio. They obviously have broken the civil protection orders at the last town hall meeting where they were there for over an hour and a half. And what did Florida do? Absolutely nothing. What's Ohio gonna do? Ohio's gonna mandate that they show up for contempt of court charges in person. And if they don't, there will be a warrant for their arrest. And if they do, great, because we already have another contempt of court charges coming for their arrest. You would think that the Florida courts would actually do something for all these violations of the civil protection orders, and thus far, they're still hanging on there in the court dockets. Now, all of her claims against me, saying that I broke the temporary injunction where all my civil rights, okay, not all my civil rights, just First Amendment, Second Amendment, Fifth Amendment, probably the 10th Amendment, Sixth Amendment. There's quite a few amendments that have actually been taken away from me illegally by Judge Craig DeThomas. Well, all of those that she claims that I violated the temporary injunction, those are falling off the docket. The state attorney is saying this is not valid. There are no charges. Nothing was violated on behalf of Jeremy. Frankly, the Florida courts should be fining her. They should be charging her with frivolous and absolutely ridiculous filings in the court system. Even if they don't, we're headed to the federal courts where we are filing against her for extortion. Jeremy, give me money, give me publicity, push my turtle rescue, promote me like crazy. Or if you don't, I'll destroy your life. I'll post all these untrue things about you and George and everybody else in Otter Creek on all of my hate pages. I'll place signs up about you. That's what she's done. She's tried to extort us for money and for promotion, and she even expected us to work. Yeah, us who work nonstop around the clock to work on her property. Wait, hold a second. Is that her property? Is it John's property? Is it her and John's property? Or is it the 501c3's property? It's definitely not the 501c3's. It's in her name, 50%, John's name, 50%. And somehow, some way, she thought that we were expected to work for her. Don't worry, I got the receipts. A lot of people want to know what's going on with this ordered hit. Well, here's yet another email by Donald, and it's huge and it's long. You know, it almost sounds as if it's LIEnette, but we know it's not LIEnette because he actually has grammar and syntax. He can put a complete sentence together. There's actual structure to his thought process and punctuation. Thank the Lord for punctuation. It's not the only emails we get, though. For example, we have an email right here from Josh. He says, Jeremy and George, my name is Josh, and I'm a retired Ohio deputy, and I've been a fan for a couple years, and it's so frustrating to see what you guys are going through. In all of my 25 years of service, I have never, ever seen a judge behave like this. And Josh, I want to clearly state to you, there are so many people around the world that have never, ever seen a judge behave like this. It's out of control, literally out of control. And when it comes to checking your vehicles for GPS devices, look on the inside of bumpers, wheel wells. Why is Josh telling us this as a deputy? Because somehow Levy County deputies knew that we were at a meeting that we never attended before in our lives. They didn't phone call us. They didn't go to our properties. Somehow, some way, they're keeping tabs on exactly where we are. And we don't know if we can trust them or not. They're obviously not doing their job arresting LIEnette and CROOK every time they should be arrested. So Josh goes on to say, when checking your vehicles for GPS, look under the inside of bumpers, wheel wells, under the truck bed, rails, between the truck bed, the cab, the grill of the truck, the whole underside of the vehicles. On a car, places like rear view mirrors, housings, behind license plates, top of mufflers, behind the plastic in the wheel wells. The GPS devices my sheriff office uses has extremely powerful magnets. Josh, let's go take a look right now. LIEnette's posted before that they were going to put trackers on our vehicle. Now, this is a pretty big vehicle. I'm looking at big wheel wells. As a matter of fact, George is so small, she could get right up in here. And I don't see anything in there. It's been so wet. Everything's splashing. Josh mentions, I really think we're going to have to do something more extensive to actually check. I mean, there's just so much, so much. He did mention the grill. Let's check the grill here as well. Now, I see a lot of dead bugs and pollen. We need a car wash.
It's hard to keep our vehicles clean here in Florida, especially with it being so wet.
What's that?
What? What?
That's a dead bug. That is a giant dead bug. Almost like a magnet to the radiator. Okay, let's look over here. And nothing there. I mean, really, we never thought we'd be in a situation where we're actually questioning what the deputies are doing. How do they know? Why do they know? And why not just come straight out and tell us how they know? Why keep it a secret that they're keeping tabs on us? When in all reality, we're the ones that have civil protection orders that need to be protected. We've had the opportunity to work with some incredible deputies in the Levy County Sheriff Office. And frankly, we've had the displeasure of some that just don't care, that seem to not take their oath very seriously. Thankfully, we have an incredible legal team as well. And because of all of this, everything has been put on stay. We filed a writ of prohibition, trying to get Craig DeThomasis removed. We're asking for the writ, a motion, or to do something of prohibition to remove him forever from this case. Let's dig into that just a little bit. We got to have a new judge. We have got to have a new judge. That's right. Jesus has got the gavel. He's ready to go. This is roughly a 49-page document, and I've taken page 1 off, but this is the writ of prohibition that Judge Craig, I struggle calling him a judge because he does not seem like a judge to me. DeThomasis gave my legal team until Friday, March 1st, 6 a.m. to get filed, or we were going to the final hearing. And it was filed because our legal team is incredible. And so we're going to show you some of this. At the beginning, you can see the petition for the prohibition, basis of invoking jurisdiction. Now, we're not going to go over all of this, but we're going to go over some of it. Statement of the case and facts, okay? And there is a lot here. All right, let's get into this just a little bit. Jeremy Hales files the petition for writ of prohibition, seeks disqualification of Circuit Court Judge Craig DeThomasis, Levy County, Florida. The statement of procedural facts with references to the appendix is set forth below. The merits ultimately involve the intersection of the First Amendment rights. That's what this judge has taken from me unconstitutionally, and then seems to think that he somehow has the legal authority to do it. Blows my mind. To free speech in Florida's cyber stalking statute. Hales and his fiancee operate a popular YouTube channel program called What the Hales. I don't know how popular it is, but we've had fun vlogging our lives. Although this has not been fun at all this winter. In a video journal of their lives with much interest generated in their treasure hunting experiences, as well as the promotional events, which include extensive charitable giving. That's what we love to film. As a Levy County deputy says, you're only doing this for YouTube. You know what? We love to film giving and helping and things along those lines. We have to film the sheriff deputies for accountability. He literally, in the previous video, as he makes these comments about YouTube, proves the point of why I have to film for accountability.
He was mocking the email, I feel.
Without a doubt. Without a doubt. They have a national, international viewership, approximately 700,000 people. They also have a stalker fan who moved across the street in a town, a population of 100. 100. You ask yourself a question. Why does LIEnette, John CROOK, move to the town of Otter Creek when they have a life-threatening child that even a cold, anything could unalive this individual, according to LIEnette. This
and
is what
further away from her
metabolic I didn't post this.
Team.
She posts this, and as George just said, further away from doctors. Now she's in fecal matter. Now she's in with reptiles that carry salmonella. Now she's with busted glass and nails and every hazard you can think of. Messed up situation here by far. Now, George and I didn't know that when we bought property here, and we're hiding out in the woods, and it works great for our business plan. The only reason they came here was to stalk, was for money, promotion, free labor. And it goes on and on and on. It says this petition for writ of prohibition arises from the trial court's denial of 3 motions filed by Jeremy Hales to disqualify Circuit Judge Craig DeThomasis on bias, complete and total bias. His name should be Judge Craig DeBiasis, not DeThomasis in all reality. The judge, on February 14th, the judge entered a 5-page single-space order denying Jeremy Hale's second order, okay? It goes on and on. Hale's first motion to disqualify Judge DeThomasis was filed December 21st, 2023, a result of Judge DeThomasis' excessive participation of a hearing on November 29th. In other words, he acted as if he was LIEnette's lawyer. This is a judge who seems he can't forget, he can't stop litigating. He's not a litigator anymore. He's not a lawyer. He's not legal counsel. He's a judge. His job is to listen. As a judge, his job isn't to keep talking or to keep guiding or keep telling LIEnette what to say. And we can go on and on and on. We go on to say documentary evidence in this record is included in the appendix. In other words, all the information is there. Transcripts have been typed up. Nature of the relief. Well, let's take a peek at it here. Nature of the relief, what are we looking at? Jeremy Hale seeks a writ of prohibition, prohibiting. You understand that's what we're doing. Writ to ask for prohibition to prohibit. We're asking for them to prohibit Judge Craig DeThomasis for further participation in the Levy County Court case. Bam! There's our number right there. 2023 DR 000416. Look at that. I can do that upside down. I didn't even know I could read, let alone upside down. You know, I've been practicing, George. Watching Sesame Street, Lamb Chop.
Way to toot your own horn.
I have not been tooting. I can promise you that. That is you. Okay, so additionally, Hales requests an issuance of an order to show cause so that the stay of trial proceedings may be effectuated pending deposition of the merits. The final hearing was set for March 1st and has been continued with the date to be determined. Good cause exists for this court to show cause order because the intolerable, look at this, the intolerable adversarial atmosphere Judge DeThomasis has, you already can see it, you can read it. I love these words. I wish I was a wordsmith.
Them is
like
fancy
this.
big words.
Big words. Okay. All right. I know some of these words. Okay. Engendered as set forth in the petition for the writ of prohibition. All right. We have a standard of review, and basically what this says is, hey, you gotta legally take a look at this. Okay. Argument. Now, this is pages and pages of what this judge has done. Pages of what this judge has done. How could a higher court not dismiss him in this case? Of course, we've seen that as we've fought against Town Hall in Otter Creek, as Levy County Sheriff Station and deputies haven't done what they're supposed to do. Court system hasn't done what they're supposed to do. So who knows? How high does the corruption, how wide does this disease spread with these good old boys in this network? All right, argument right here, as you can see. Judge DeThomasis, lengthy, self-indulgent orders denying motions to disqualify are themselves independently basis for disqualification. Now, you have to understand we have filed 3, not 1, not 2, 3 motions to disqualify him. And all he is legally supposed to do is say yes or no. Instead, what he does is write lengthy book reports, lengthy
defensive reports.
That's what it is. It comes right down to his legal background. He was a defense attorney for years and years and years. This is a judge who is not experienced whatsoever. He's cutting his teeth on his black robe syndrome right now. He is a babe in this robe, and he still thinks he's some kind of lawyer. And I can't even imagine why he's spending all of his nights typing all of this information up, his weekends, typing all of this information up. Yes or no? And because he hasn't said yes or no, that in itself is the reason to independently, 3 times, disqualify him, get rid of him. When a trial court looks beyond the legal sufficiency of a motion to disqualify for a basis and attempts to refute all the allegations, it exceeds the proper scope, and the disqualification is required on that basis alone. Regardless of the correctness of the denial of the motion as legally insufficient. And all the case law is in here. And you can see that Craig DeBias loves to defend himself. I mean, my goodness, he loves to defend himself. You know who I want defending me? This judge. Yeah, with that gavel. All right. Judge Craig DeThomas, however, seems to believe that in 2024 that a trial court may comment on the status of the record when denying a motion to disqualify for bias. However, this has not been law in the first DCA where the Levy County Courthouse lies. Nonetheless, paragraph 4, watch this, paragraph 4 of the judge's 228 order denying Hales, this disqualification motion states, in this court's prior order issued on February 14, 2024, under subsection, oh my goodness, here we go with the subsections and the times and 13 seconds and Mark Feather! All right, subsection 7A through F, the court explained the relevant and material status, sorry, George, I have to read it this way. The relevant and material status of the record, not by taking issue with the averments contained within the motion under review, but rather by identifying that it was true that there were several transgressions from the applicable law and procedure engaged by counsel. Mark Feather! Throughout the proceedings, which were addressed by the court as they arose. Yeah, addressed by their court again and again and again and again. It will never stop. This man needs to issue an injunction on himself for Mark Feather. He's obsessed. He won't let Mark Feather go. By the way, Mark Feather is going to be on our Sunday Night Live. That's scheduled currently. So stay tuned.
Mark your calendars.
8 p.m. this Sunday evening.
Mark Feather your calendars.
You better Mark Feather everything up. You better, yeah. Cheers, Jesus. All right, this is water. He did not, I know what you're thinking. He just turned this water into wine. That did not happen.
We are not sponsored by that sparkling water.
He turned it into lime. Cherry lime. All right, not wine, cherry lime. All right. So it goes on again and again, and this says, no other reason for denial shall be stated. That's the law. Judge Craig DeBias can't go on these lengthy orations of why he's so right and why he's Jesus, but Jesus isn't Jesus, okay? And so by his own denials, that is basis for disqualification. Now, and you can see it over and over again as far as the case law. No other reason for denial shall be stated. Some, contrary to the law, no other reason for denial shall be stated. This is all case law here. All case law here. All right, and we go on. Mr. Hales is having to address matters in Ohio court related to this situation. He has to be tomorrow morning. Based on such a representation, the court continued the matter which at the time did not have any temporary injunction relief in place, to reconvene on 12/6/23. Now, in the last hearing, Craig DeBiasis said that it was my fault. All these continuations are my fault. No, this was because he allowed LIEnette to just ramble in circles, and he guided and he directed her. And then court was closing at 5 o'clock. That isn't a continuance based on me. That's a continuance based on him, which I had a flight the next morning to Ohio to deal with things in the Ohio court. Nobody said it was a court hearing. It was to deal with things in Ohio court. They have violated, John Crook and LIEnette both have violated our civil protection orders. And they had a hearing on it based on all of what they've done January 10th. We're still waiting for that verdict.
Well, that first hearing, we watched other cases ahead of us, multiple cases, and they took 15 minutes.
15 minutes!
15, 20 minutes. Hers took 2 hours.
Oh, my goodness. All right. And it just goes on and on and on. Tribunal and such. This is what he's done. Tribunal and such behavior was addressed on 123/24 at the courts, considering the totality of the circumstances in the case. We're deliberating. I mean, it just goes on and on. C, further, despite the clear dictates of the Florida Supreme Court in Administrative Order AOSC 11-22 in the 8th Judicial Circuit Administrative Order 1.14, Volume 2, there was an undisputed evidence that confirmed an attorney for the respondent, Mark Feather, despite having previously signed an document that he was aware and admonished regarding the prohibition of dissemination of unredacted copies of court proceedings, which are the same as redacted. Unredacted, redacted, all the same. There's no confidential information. Therefore, there is nothing to redact. I hope everybody understands that. And then what happens is this states that Craig DeBiasis declares Mark Feather guilty, even though Craig DeBiasis is not, Judge Grudge is not the presiding judge over the case, but he declares my attorney guilty.
What's he guilty of?
Well,
what's the judge guilty of? He's guilty of all kinds of stuff.
Jesus, can you give me a little help? What's Craig DeBiasis guilty of? Bias. Yeah. I know. He said Craig Judge DeThomas is a brood of vipers, a whitewashed sepulcher, and a few other things. He actually said that he was a tax collector as well. And if you know anything about Jesus's culture, Hebrew culture back in the day, the very worst insult, okay? You could be called a harlot, and if you understand what a harlot is, that would be, you'd find a lady out in the streets in the middle of the night and you have an interaction, that's a harlot. That was a higher standard, that was a higher acceptable thing in culture. The lowest of the low was being a tax collector. And that is the ultimate insult was to be a tax collector. And he said that Craig DeBiasis would be an incredible tax collector. Okay, let's go on. We've got page 9. Let's just move page 9 on over there. Okay. Boy.
More receipts.
More
proof, more timeline.
Way too much.
You can't say screenshots. I mean, it was printed.
It's actually printed, but
double spaced.
But the good news is, I got the good judge on my side this time. So even if DeThomas isn't on my side, all right. So let's keep seeing what's in here. So clearly, Judge DeThomas criticizes Hale's attorneys, mostly Feather. Yeah. Mark Feather, we've all seen that over and over again, right? For violating administrative rules of court. But the fact that Judge DeBiasis, or Judge Grudge, or Craig DeThomas, included that information on an administrative rule violates his order denying a disqualification motion, which is not to give any other reason or any reason for denial, which suggests that Craig DeThomas himself violated an administrative rule in the course of trying to humiliate somebody for violating an administrative rule. I hope you get that, okay? Judge Grudge Craig DeThomas is trying to embarrass Mark Feather, saying you violated an administrative rule. As he's doing that, the judge is violating an administrative rule. So, in other words, it's okay for Craig DeThomas to violate a rule.
Because he wears the black robe.
It's not okay for Mark Feather. Hale's second disqualification motion, filed 2/11/24, was based on Judge DeBias's, because he has so much bias, conduct and comments on a non-evidentiary live hearing on 1/23/24. Essentially, for 90 minutes, the judge beraged and cross-examined Attorney Shockett, the only attorney present on Hale's behalf that day, with hostile, accusatory, and degrading remarks that were actually directed to all three of Hale's attorneys for various perceived transgressions, past, present. The judge numerous disapproving comments about Hale's earning income and exaggerating his fear not getting a fair trial. Why does the judge care how I make money?
I mean, the judge is making money by berating all of you guys and insulting the attorneys.
Judge is getting paid. I get paid. Let's see. Well, how do I make money? Number one, I'm a landlord. I've been a landlord since age 29. I'm 46 now. Did I say 21 or 29? I've been a landlord.
I heard 21.
Okay, good. Okay,
maybe because I knew it was
here.
21.
So 21 is when I started being a landlord. Real estate's the way to go. Okay, I buy and resell. So there's an entire resale business. There's other little side businesses that I have an investment in. I have YouTube.
Merch.
YouTube is part of video vlogging our lives. And if there are individuals and fans that want to send income and super chats and they want to help, who am I to rob them of that blessing? Because what I want to do is be a blessing to others as well. As a matter of fact, I'm surrounded by Christmas in the Creek right around me right now. And it's going to be very difficult to see because we don't have all the lights on it. But I want to use what God has blessed me with and bless others, and I feel good because of that. Proverbs 27, verse 19, I think it is. He who refreshes others, he himself is refreshed. I love to give because I get refreshed in my spirit, my soul, and my heart by that. And so there are fans that want to be just like that. They want to give. They want to be a blessing. They want to refresh. There's nothing wrong with that. And nor would I ever try and hold that blessing back from them, because I'm a person who wants to bless others that way too. So I get it and I understand. Why does it matter how I make money? It doesn't matter how I make money. As a matter of fact, I've been very, very adamant about not making money off of Otter Creek in the aspect there's no t-shirt sales where I could have, 500 different ones right now. Everything from I don't do emails to he's not corrupt to my mother didn't die, right? Or ugh. I think I have that one over there. But a fan sent it. Yeah.
We do a lot of charity work. We give away a lot of money. And that's how LIEnette ended up in this mess, because she wanted part of the charity.
They're here. Period. All right. And we go on. All right. And we've got the 1214, the 228 orders. They refute allegations of the disqualification motions. Now, keep in mind, he can't refute. He's not a litigator. He's just supposed to say, nope, not sufficient. And when he says all this stuff, that is reason to disqualify him. So despite the judge's bare contentions in both orders, he was not passing judgment on the truth of facts alleged. He still did so. By the way, that's what he said. Look right there. He said he was not passing judgment on the facts alleged. And therefore, by saying that, he did exactly that. He passed judgment on the facts alleged. In fact, it's rather troubling that Judge DeThomas confidently states that neither of his 5-page, single-spaced orders of 214 or February 14th, nor his 3-page single-spaced order of 228 or February 28th passed on or took issue with any facts. The record already reflects these orders passed at least some facts directly. For example, paragraph 9, 224 order. Judge DeThomas wrote this: any objective review of the proceedings held on 1/23/24 would not cause a reasonably prudent person to fear not receiving a fair trial. Guess what he just called me? Unreasonable, not prudent. He said I'm not normal. And yet The world is watching these trials and going, this is the most biased judge they have ever seen in their lives. Judges are watching, lawyers are watching, paralegals are watching, deputies are watching, cops are watching, the average person who is a laborer, the businessman. It doesn't matter who they are, male, female. I don't care if you're black, white, yellow. It doesn't matter. They all come to the same conclusion.
They can smell the biases through their watching device.
They sit there and say, I have never seen anything like this in my life. And according to Judge Craig DeThomasis, you are not reasonable and you are not prudent if you fear me not receiving a fair trial. This judge goes on to say in my second disqualification motion that my statings in there are, illogical, irrelevant, and inconsequential. His biases. We're talking about his biases. They're unacceptable. They're irrelevant. It just goes on and on and on and on and on. It appears that the judge misunderstood the nature of advanced in the alternative as being the same as two arguments involving competing hypotheses. He nonetheless should have refrained from offering any comment at all. And yet he can't stop. It's not like he has a YouTube channel and dead air is bad, right? Whenever you're listening to the radio and there's dead air, you're like, this is not good. It's not like he's watching TV and all of a sudden there's dead air. You're like, this is not good. You ever watch a sporting event and they have the main commentator and then they have a color commentator because one person can't hold the entire conversation. It's the same thing George and I do. Our agreement was I would be the main commentator, she would be color commentary as she felt comfortable. And so dead air on YouTube is not good. And yet dead air for this judge is exactly what's expected. He's not out entertaining, educating, even though he thinks he is from the bench constantly. All he is there to do is to listen. That's it. That's it. He nonetheless should have refrained from offering any comment on all, considering he was drafting an order denying a motion to disqualify. Judge DeThomasis, his rebuttal of factual allegations contained in Hale's motions was not cured by a qualifier, that he was not passing judgment on the truth. This is what he says. He says that he wasn't passing judgment on the truth of the facts that were alleged. And the facts are, I fear getting a fair trial or getting a not fair trial by him. There's no way. This man is completely and totally biased. This man is bent to make law, new law, and have his name attached to it. He is 100% against free speech. This is constitutional, foundational law, and he has no care. He wants to take the gavel and he wants to start busting out the foundation. Not okay in any court. All right, but it goes on. Judge DeThomasis running problematic on counsel's unacceptable behaviors and actions to the law. It just goes on and on and on to the point where the veiled threats to report my counsel to the Florida bar are objectively reasonable basis for Hales to fear they will not receive a fair trial. He's literally threatening all of my lawyers, saying, I'm going to submit you to the bar. Now, he's made lots of threats already. He's made threats that he's going to call my Ohio lawyer. He never has. He's made threats that he's going to call the Ohio judge. He never has. He's made threats that he's going to submit all three of my legal team members to the bar. Whether he has or not, I don't know. But it's not okay. It is absolutely not okay. And here is actual right here, Judge DeThomasis on 12/14. He is going to, we go through all this, place the record specific criteria concerns of the court as was done in each of the prior hearings, and allow responses for counsel, if any, concerning any and all transgressions and or violations of the law and or standards. He's condemning my legal team. He's condemned me. He's condemned my legal team. And that's not his job. His job is to listen. That's it. Listen. That's it.
Listen, Linda.
Page 20, another huge issue. The record reflects that Judge Craig DeThomasis' intention to indulge in this exercise regarding the sequestration issue, which the judge appears to be applying in an overly broad fashion to Hales and his witnesses. I haven't even brought any witnesses to the table yet who have not yet begun to testify, nor were they even sworn in. But specifically, Judge Thomas has stated that when the parties return for trial on March 1st, the court's going to start conducting inquiry as to who spoke to who and will issue sanctions. Do you understand that that's consequences to me? He's going to issue sanctions based on my witnesses talking. We haven't even brought a witness to the table yet. LIEnette's not even done bringing evidence to the table yet.
We're still
Not
waiting.
that she actually has any. And then the judge goes on to say that when the parties return on March 1st, he's going to conduct inquiry to who spoke to who. He's going to issue sanctions, including the exclusion of their testimonies. My goodness. So I already know you're thinking, okay, if George is a witness, you and George aren't allowed to talk to about this because Silver Scam says, I want to invoke sequestration. And Thomas says, yeah, of course. Yeah. And now it's going to be, wait, you and George can't even talk about this case? I'm not talking to George about this case. I'm talking to a camera. I'm talking to an object, an inanimate object. Now, George is on the other side. She's in the area. And so is Silver Scam going to try and have her removed as a witness? Absolutely. Based on this ridiculousness. You understand I'm not getting a fair trial with the Thomases. I know you get it. I absolutely know you get it. In light of the demonstrable history of the judge's treatment of the parties, including he cherry picks, selective interpretation and application of administrative and procedural rules as between the parties in this case, and his hostility expressed condemnation of Hale's counsel, Hale's fear for not receiving a fair trial is well-founded and reasonable. And I know you feel the same way. Don't let this man call you irreasonable. You are extremely reasonable. You see exactly what he's doing, and we can't let him get away with this.